Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Be seated. Mr. Miller?
Yes, Your Honor. Mr. Chief Justice, may it please the Court. My name is David Miller, and I represent the petitioner in this matter, the people of the United States of America. Your Honor, the government respectfully requests that this Honorable Court reverse the decision of the 12th Circuit for the following two reasons. One, there is no reasonable, objective expectation of privacy when a person travels in their car on public roads of the United States. And two, by attaching a GPS device to a respondent's vehicle on a public road does not invoke the protections of the Fourth Amendment.
Counsel, I have a question in regards to the trial court's indication of Leon and there not being one word said in the appellate court below. Did you raise that issue before the Court of Appeals?
No, Your Honor, we do not believe we raised the issue before the court. Well, with Leon, Your Honor, on whether the exclusionary rule should be applicable, we decided that because of the warrant going one day after, we decided that we would rely instead on our precedents, the court's precedents holding in Knox and its other decisions in attacking the decision of the appellate court.
So you waived this, and this is probably your best argument.
Your Honor, we still believe that with the exclusionary rule held up in Knox and again issued again...
That's not my question. Have you waived the Leon issue?
Of exclusion?
Yes.
Your Honor, we would still like to reserve the issue of exclusion for this court.
You didn't raise it in the Court of Appeals.
Your Honor, we would still like to present it, but if possible, if we would like to waive it, we would be glad to waive it and go on to our other arguments.
Proceed.
Under United States against Knox, using precedents set forth in United States, or Katz against United States, Cardwell against Lewis, and Smith against Maryland, this court has uniformly held that the application of the Fourth Amendment depends on whether the individual invoking its protections has a justifiable, legitimate, and reasonable expectation of privacy against unlawful government intrusion. The court, in making that assertion, depends on two things and two questions alone that were raised in Justice Harlan's concurrence in Katz. Those are, one, whether the individual has a subjective expectation of privacy and whether they moved to keep that behavior private, and two, whether society is ready to recognize that subjective expectation as objectively reasonable under the circumstances.
Counsel, you're arguing now that this is not a search. Is that correct?
Your Honor, we believe that under United States against Knox, because a point A to point B...
My question again, Counsel, is are you arguing what my question just was?
Yes, Your Honor, we are arguing that this was not a search.
Then why did you get a search warrant to start with?
Your Honor, we believe that the ancient Hannibal received the search warrant just as a superfluous extra protection on the behavior that she was going under in anticipation of the evidence that she was going to obtain later on in court.
So the officials anticipated that it possibly could be a search?
Your Honor, she just believed that by getting and going that extra mile of getting a warrant, that it would help her case further on in the case against Respondent Barker.
So she believed that it was necessary possibly to have a warrant?
She did believe that, yes, sir. Despite whether she got a warrant or not, under the United States against Knox, we still believe that when a point A point to point B, when a person travels on public roads, there is no expectation of privacy because they are putting themselves out to be viewed by any member of the public. And as this court held in Cardell against Lewis and Smith against Maryland, along with the United States against Knox, that any behavior that can be reasonably expected to be viewed by the public should not be against the rules for the police to view, because that would be just, unreasonable under the Fourth.
Did not answer the question of for how long could you anticipate the tracking of an individual, or was that limited strictly to a one-day tracking of a beeper?
Under United States against Knox, Your Honor, the court held that it was only that one point A to point B and left open whether or not a kind of a dragnet type of surveillance would be constitutional under the Fourth Amendment. But the government believes that because one point A to point B travel multiplied even over 28 days, every one of those individual events is still viewable by the public at large, and therefore the individual has no reasonable expectation of privacy during that entire event. Furthermore, under cases such as United States against Caro,
you concede. Do you argue that you're only arguing this case, or are you arguing for a rule that applies to all cases with similar facts in terms of a responding device and length of time and so forth?
Your Honor, we are arguing very broadly here that the use of GPS tracking devices on vehicles, whether it's 1 day, 5, 28 days, or 5 months as in Caro, does not violate an individual's Fourth Amendment rights.
All right, now, does it intrude on an individual's right to have the state know everything about you over 30 days? I mean, as some of the briefs have indicated. In over 30 days, people know what doctors you go to. They know what your health problems. They could know what your health problems are. They know what your religion is. They know who your social friends are. They know whether you are, as someone said, cheating on your wife or husband or whatever it may be. I mean, they know a very detailed personal knowledge that you do not want the public to know, or that you certainly don't state. Now, is that not an intrusion on privacy that's protected by the Fourth Amendment?
Your Honor, the government believes that that's not an intrusion of privacy because each of those events occurs in the public realm. So whether or not a person...
Not really altogether, does it? They take her to the doctor. I mean, you can assume that if they take her to a particular address, they know what kind of doctor she's going to.
Yes, Your Honor. But in this case, because that event of driving from her home to a doctor's office occurred on a public road, anybody from a neighbor to a pastor to anyone be able to see that and say, oh, Miss Vargo went to
her. But it tells the police a lot more than that. And it's the state that does the invasion of privacy, not the public.
Yes, Your Honor, but each of these individual events still occurred in a public fashion so that anyone would be able to see them. The court has never used the kind of Mosaic theory in determining that the cumulative effect of many different individual events.
But isn't the dichotomy between public and private conduct simply a matter to determine whether privacy has been invaded? And sometimes, I mean, a public disposition for your conduct will indicate private conduct that a reasonable person would intend to claim a right of privacy too.
Your Honor, I respectfully disagree just from the sole fact that over the time, when the person conducts these behaviors in the public realm, they have no reasonable expectation of privacy.
She's not conducting going to her doctor. She's not conducting going to her friends. She's not conducting going to church so that the entire public would know.
But the difference in this, Your Honor, is the GPS tracking device merely would give the information that she traveled from her home to maybe the parking lot in front of this or to the church. It wouldn't specify the specifics that you are alluding to.
That's false reasoning. It tells you much more than that. It tells the police exactly where she went.
But the police reasonably, Your Honor, could follow Respondent Vargo for 28 days and apply shoe leather down by applying in undercover cars or helicopters or any means to actually put forth the manpower to track her. What the GPS device gives is much less detailed information.
Well, you say that the precedent allows that, and that's true. But that doesn't mean that it's not an intrusion of privacy that may attract the attention of this court as an invasion of one's privacy under the Fourth Amendment.
Yes, Your Honor, but under current precedent, we do not believe that any behavior that an individual puts out in the public in such a way...
Can we change precedent?
Absolutely, Your Honor.
Right.
But As this court has stated in its flyover cases of Dow Chemical against the United States, California against Cirillo, and Florida against Riley, even when a person purports to protect their curtilage against unlawful public view, that anything that can be observed by the public is still allowed.
Well, where do you draw the line, counsel? If it's not 28 days, what is it, a year, 2 years?
Your Honor, under United States v. Caro, this court has held that up to 5 months has been allowed, and several courts have allowed up to 2 months and 3 months of constant viewing. The United States does not have an opinion on how long is too long, but we do believe that if the court wanted to make an absolute rule, as they did in Maryland v. Schatzer, we would say that they could go up to anything above what they decided in United States v. Caro.
You can't deny that the rule you argue for would permit the police to track down anybody without suspicion or probable cause of having committed any crime in the same fashion that you track down this particular criminal in this case.
Yes, Your Honor, but
What does? What prevents the police, what prevents the state from intruding on an ordinary law-abiding citizen if it's not the Fourth Amendment? And you say the Fourth Amendment doesn't apply.
Well, Your Honor, the government would contend that the economics of the current police forces would affect that. The kind of dragnet surveillance that Respondent Vargo alleges could take place if the court, upholds this.
When does it become a dragnet? I think that's the question that we're all seeking. At what point in time does it, if we know from Knox that one day they didn't even ask for a search warrant, and we said that that's okay. And then there's the language about the dragnet. At what point in time does the dragnet become effective?
Your Honor, I believe that the dragnet will become effective when there is sufficient evidence out there that states that there is that kind of surveillance going on. Right now, there is no evidence within the U.S. that the police are using massive amounts of GPS trackers to just put on random neighborhoods and then use, huge amounts of the police force or computer energy
Did you ever hear of the Patriot Act?
Yes, Your Honor, I have.
Okay.
We still contend, Your Honor, that the Patriot Act and the provisions for warrantless tracking in that regard are different from the Fourth Amendment protections in this case. Here, we're talking about a legitimate government interest, that the police need to be able to follow people and use technology to assist them in their law enforcement duties.
But there's no restraint on it.
Your Honor, the government contends that the economics of the police force are a natural constraint in making sure that the police don't track an individual for 6 months, 1 year, up to 20 years. Because
that would be true if it involved visual surveillance, but we're not talking about visual surveillance. This respondent will tell you it went to 1405 Smith Boulevard, tell you exactly where it went. All they've got to do is put it on the computer and it doesn't require anything.
Right. Yes, Your Honor, but this court in the United States against Knox did hold that, technology that assists the sensory capabilities of the police is allowed. So what the GPS tracker...
But to your point, the imagery, sort of the thermal imagery from the outside of the house going inside, that's not permissible.
Yes, Your Honor. In United States versus Kylo, the court did hold that thermal energy going into a person's residence was not permissible. But Justice Scalia, in writing that opinion, did state that it was the house that made the differentiating factor in that case. The house, above all other things, is protected more because of its sanctity under the Fourth Amendment. And
Does inside the car make a difference? Let's say that the individual is inside the car, and I use the thermal imagery to determine that you've got 40 pounds of marijuana in there.
Yes, Your Honor. The government does think that if thermal imaging was used, or on the alternative, a GPS tracking device that was able to listen to conversations within the respondent's car would completely change the analysis of this court.
Why would that happen? Because in the Beeper case, they went in and they put it inside a canister that was put inside the car, and they tracked it that way, didn't they?
Yes, Your Honor. In Knox, the police had permission to install the beeper device on the can of chloroform, which was then sold to the...
But not by the defendant in that case. The consent was given by the merchant who had the material.
Yes, Your Honor, which is why there's no standing issue that was brought up in that case on whether or not it was constitutional for the attachment of that GPS device on that. Your Honor, I see I'm running out of time. The second thing I would like to bring up is the attachment of the GPS device to the actual car. Under this court's holding in Cardwell against Lewis and New York against Class, this court has held that the exterior of the car does not afford the same constitutional protections as the interior because it is able to be viewed by any member of the public. Therefore, the government contends that the attachment of the GPS device to the undercarriage of the car on a public street did not violate any constitutional protections of Respondent Varga because following that precedent, it did not, one, was not a search and was not a seizure as recognizable under the Fourth Amendment because it did not interfere with her possessory interest in her vehicle.
Counsel, if that argument is correct, then I go back to the question is why did you take the time to go to a magistrate judge to indicate that there was probable cause, and on the basis of that probable cause you could attach a GPS to the outside of the vehicle? That seems like a contradiction in terms. Either you needed the warrant or you didn't need the warrant. And why did you go get the warrant again other than say, well, we were protecting ourselves just in case?
Your Honor, I see I'm out of time. May I briefly answer the question and conclude? Your Honor, I cannot speak to why exactly Agent Hannibal decided to seek out the warrant in that case. We do believe that she decided to get it strictly from the fact that she had so much probable cause against Respondent Varga that she wanted to cover all her bases. But the question before this court still remains that absent that warrant, whether or not it was needed, and the government contends that under current Supreme Court precedent that it was not a search or a seizure under the Fourth. Your Honors, for the aforementioned reasons, we respectfully request that this honorable court reverse the 12th Circuit's decision. Thank you.